Hello and welcome to the third episode of the podcast series ERA Talks. I'm Jean-Philippe Rajad, the director of the Academy of European Law. Our guest for this episode is a Belgian jurist, a leading scholar, professor of European law at CJEU Leuven since 1983, and a judge, a European judge since 1989. He has been the president of the Court of Justice of the European Union since October 2015. On the 1st of April, we had the great privilege of interviewing Koen Lenaerts. Enjoy the interview. President Lenaerts, thank you very much for accepting our invitation to take part in the podcast series ERA Talks and for welcoming us to the Court of Justice in this wonderful studio. Thank you very much.
My pleasure.
This October, you will be celebrating 10 years as President of the Court of Justice. But your career with these institutions dates back to 1989, when you were appointed judge at the General Court. It was called Court of First Instance of the European Communities at that time. But even before, you worked for a couple of years as a référendaire.
84-85.
84-85 with Judge Joliet. And with this series, ERA Talks, we are pursuing also an educational objective, I would say. I mean, this is part of the DNA of ERA. This is also part of your DNA, education. And therefore, I propose, considering all your experience at the court, that if you could give us the key to better understand the changes, the evolution of the court since you started as a référendaire until today, so that we can better understand what the court is now for.
The main change is that the court now deals with matters which the member states have conferred as competences on the European Union by successive treaty amendments, which were simply unimaginable in 1984-85 when I was a référendaire. And I stress the years 84-85 of the last century, because that is before the Single European Act. And people, also lawyers, realize insufficiently what a paradigm shift the Single European Act has been. 1987, concluded in 86, entered into force in 87. And it holds in 5 words, and in some languages, including German or Dutch, my native Dutch, only 4 words. An area without internal frontiers. Ein Raum ohne Binnengrenzen. And because Binnengrenzen is 1 word, it's only 4 words in German and in Dutch. Een ruimte zonder binnengrenzen. Why do I stress this? If the crossing of a border between member states is no longer the trigger for controls on persons and on goods, you necessarily need to manage in common as a state parts of your own sovereignty relating to sovereignty-sensitive matters such as asylum and immigration. Because when you cross the external borders, de facto, if not necessarily de jure, you are in the area as a whole. The same applies for judicial cooperation in criminal matters. You cannot accept that people escape their criminal liability simply by returning over the open borders to their own member state whose nationality they possess, for instance. And then, the fact that there is an open space, an open area, makes it people find it absolutely natural to work and live and go as tourists or as retired people or as artists to other member states. Many more private international law issues arise in the family law field, in the patrimonial law field, etc. So I'm only here intuitively making clear that the Union now is dealing with almost all aspects of the law in general, and is no longer confined to what it was in 1984-85, common market law. At that point in time, union law, then community law, was seen as a separate subject matter within the global law field, something for specialists. Economic law, basically, free movement of the four factors of the economy, workers or self-employed, goods, services, capital, economic factors. And then competition law, a bit of state aid, common agricultural policy, which was still a market issue, common transport policy, and a little bit of external trade law, common commercial policy. So it was all confined to the economic, commercial space in the law. Now, union law extends no longer as a branch of the law, but as a source of law, a source of legal rules in all the subject matters of the law, whether it's insurance law, employment law, banking and financial law, environmental law, industrial relations law, everything. In all the fields of the law, also family law, even inheritance law, the law applicable to inheritance issues. Yes, because people acquire property much more easily. It's an open space. So the 5 words inserted in the definition of the internal market in 1987, common market to the internal market, it's not just a change of adjective. It's a substantive qualitative leap forward, saying it's an area without internal frontiers in which there is free movement of goods, persons, services, and capital. That is the common market definition, the latter part of that definition. But the first line which is added is crucial. And so effectively, when you look at Maastricht, Amsterdam, in Amsterdam suddenly that same area without internal frontiers is now labeled as an area of freedom, security, and justice. And for good cause. You need not only to be able to move freely, but also securely, and in an atmosphere in which justice will be done if need be. So that is why the court now is dealing predominantly with fields which are not in their core essence economic. When you take the Grand Chamber judgments over a year, there is, let's say now, between 40 and 50 judgments of the Grand Chamber, which is our constitutional solemn bench. There may be 2 or 3 which are economically rooted. All the others relate to subjects of the law in all areas, no longer internal market or market to court linked. And that is the main change. Now, that is not astonishing. The working ambit of this court develops strictly in parallel with the development of the competences of the Union. The cases which are now important are all the GDPR cases, the protection of personal data and privacy in the digital environment. You know the case law. The balancing between privacy and security concerns in the member states. The whole case law which was triggered by the Digital Rights Ireland and Zeitlinger case of May 2014. When I was a referendar, the most sensitive case was on the Reinheitsgebot des deutschen Biers, so the purity of the German beer or the ingredients of Italian pasta. And those were symbolic files which then, especially the member state concerned, looked at specially. But in a way, it was the court of which Eric Stein, the professor in Michigan of European Union law, wrote, tucked away in the fairyland of Luxembourg. The court is making judgments which in fact don't stir up any feelings with the larger public. That is no longer the case. Now the case law is on the need to recognize a same-sex marriage concluded in one member state, to recognize it in another member state which does not know same-sex marriage. So, needless to say, this is family law, combined with free movement law. And what about the Mirin case of last September, or beginning of October better, 2024, on the registration of gender identity, which had changed in one member state, registration in another member state. And I can go on like this. So it's all subjects which are pretty much politically divisive at base within the member states, within each one of the member states, and of course a fortiori between the member states. Of course, we are not making political choices. We are making reasonings in law, coming to an outcome, but the impact of our decision is of course extremely relevant in political context, in economic context, in cultural context, in ethical and historical context, and so on. So that is the main change. But for me, and it's maybe also an interesting topic for academic research, the qualitative jump between the first 30 years of European integration, between the Treaty of Rome and the Single European Act, it's 30 years. That was a common market project. And solely that. Since the Single European Act, it is a development which not only the subjects always quoted, like the citizenship of the Union and the single currency, it's all very important. But crucial is the area of freedom, security and justice with all its sub-rubrics which I have mentioned. And of course all these elements, all these subject matters are also human rights sensitive. That's why we have the Charter of Fundamental Rights of the European Union. As part of our own constitution, between quotation marks, which is the treaties on which the Union is founded, which serve as what they beautifully say in French, le bloc constitutionnel, the constitutional block or foundation of the European Union, which of course necessarily needed to include a Bill of Rights, that is a Charter of Fundamental Rights of the European Union. So it's this whole change over or development of the Union as a common legal order whose identity rests in Article 2, the 12 values of the Union, and I count them to the number of 12, that is both the first sentence and the second sentence, in a society characterized by all values, and they're to the number of 12. Let that be the 12 stars of the European flag. And now we're working on that basis in all the areas of the law where the member states have conferred competences on the Union. It covers the law almost generally across the board. So it's really another type of court which I'm presiding now than the one in which exactly 40 years ago I was working as a young referendaire.
Thank you very much for this clear overview, which I'm sure will be very helpful for the next topic I would like to discuss. About 8 years ago, ERA organized a congress to celebrate its 25th anniversary. Yes. You were there. You were one of the keynote speakers.
I'm a faithful.
Yeah, we are grateful as well, even more. And the overall theme of the congress was the authority of European Union law. Mm-hmm. And I would be interested to hear your views on the authority of the Court of Justice, or rather on the authority of its case law. Mm. Because what we see in recent years is that some of the decisions of the Court of Justice have been challenged, I would even say contested, by some national supreme or constitutional courts. I think the case law is well known, and I mean it culminated in 2020 with the Bundesverfassungsgericht. And my questions to you, because I'm more, how do you explain this contestation? Are you worried about it? And maybe the last one, how to prevent this in the future?
Well, first of all, I should congratulate you on the way you are asking this question. You speak about the authority of the Court of Justice. And I like the term because it reminds me of the writing by Alexander Hamilton in the Federalist Papers 230 years ago. You know, the Federalist Papers, these drafters of the Constitution for the United States of America, who had to convince the then 13 state legislatures to ratify their product, that is the Philadelphia Convention, which had been signed on the 17th of September 1787 in the United States. It's my field of academic comparative constitutional law research, as you know. And they had to convince them. And there was some reluctance by the constituent states vis-à-vis a strong federal judiciary. And that is why in the US Constitution it is said in Article 3, after Article 1 says the legislative power is vested in the Congress, the executive power is vested in the President. The Article 3, and you see immediately it's a compromise, says, and the judicial power is vested in one Supreme Court and such lower courts as the Congress may from time to time establish. That's the literal wording. Now, knowing that there would be resistance in the states against a powerful, I'm now using the word power, federal judiciary, which would possibly put in the shadow the state judiciaries which already existed from the English time throughout the 17th century and then well in the 18th century, Alexander Hamilton, in defense of the Constitution, said, don't worry too much. The judiciary is the least dangerous branch. The words figure literally. It has not the power of the sword. It has not the power of the purse to levy taxes and to spend money. It has only the authority, not power, authority of persuasion. And it then needs the executive and or the legislative power to enforce their judgments, Volkstreckung. Well, as a comparative constitutional law academic, I've always been very much impressed by that text, which is 230 years old, but which is absolutely present-day literature. The Court of Justice of the European Union, in the Hamiltonian sense, must persuade. It must be persuasive to establish the authority by the cogent character of the reasonings supporting the operative part of its judgments. A court must convince, must command the authority of stating the law, even in very sensitive political contexts, a deductive reasoning from values, principles, and rules, like Ronald Dworkin has put it forward, from the general to the specific, dogmatically sound, and convince that that is the way to go, settle litigation, one case at a time, not overbroad. The court is not a legislature, one case to the next, in a modest way, always ready to be challenged, to come to a deeper view, a better view, and even more strongly reasoned next time around. I say this because it serves as the immediate background and even an answer to your question. There is no problem with the authority of the court. I would almost say, on the contrary, we now take much more painstakingly into account the several steps of our reasoning analytically. We compare far more expressly than it was done 10, 15, 20 years ago, how the present case to be decided relates to sort of cases which at first blush are close yet different. So much more like a common law judge handles the case law. And this in interaction with the parties before the court. And the parties, in all these preliminary references, That's, of course, all those mentioned in Article 23 of the Statute of the Court, first and foremost, all the member states which have the right to make observations in writing and orally to the court. And the court really engages with all these arguments to support its reasoning. That is why I'm saying, yes, you refer to a few cases which, fortunately, in the 72 years of existence of the court, you still can count on the fingers of one hand. Everyone speaks about Lantova, of the Czech Constitutional Court, Ajos of the Highest Raad in Denmark, and then you have the vice judgment, and you might maybe add, but those cases are pending, we're not going to speak about it, some judgments of the Polish Constitutional Court. Now, in all these cases, yes, there has been a frank confrontation by national courts. We take that very seriously, and we try to do better and more deeply reasoned next time around. But what we should know is that in all these cases, and it's important to stress that, a solution has been found, and there has not been an actual clash and a sort of a definitive blockage or blocking of the union legal order and the national legal order. Take the vice judgment. It's a good example. In fact, the Bundesverfassungsgericht was critical in the way we had applied the proportionality test. We read that judgment very carefully. They have cloaked that in as an ultra vires problem, which is slightly problematic because normally the existence of competence precedes the exercise of competence, and proportionality is, in our case law, still today, in the second stage. But that is now the merit. But what we read when we saw the judgment is, all right, we should explain it better. That's what we do. And then we were pretty much assured that the Bundesverfassungsgericht wanted to give that signal to take judicial review of the competence division very seriously. And they're right. We have no problem with that. They're right to say to the Court of Justice, you should do it. Because we are the only ones who can do it. And the vice case shows it. They said, well, if it's not sufficiently reasoned and clear that it's proportionate, it might be ultra vires, but they didn't definitively say that it was ultra vires because they needed more explanation. And having got one or another more text, which by the way we had all seen here as well, when they had seen it as well, they said, well, yes, that is sufficient. And the Bundestag finds it also sufficient, and it was all done. So in the judgment after the judgment of the 29th of April 2021, so for a few days, exactly a year after 5th of May 2020, they refused to order the Vollstreckung. The whole thing died a quiet death. And that's how it must be. There has not been 1 minute that the Bundesbank interrupted its participation in the program. So nach wie vor, they continued to work on the basis of our judgment. And that's how it must be. And that's also why the Commission, fortunately enough, I may now say it's all behind us, withdrew the infringement action. Because the relationship between a national constitutional court and our court is one of trust. And we do trust the Bundesverfassungsgericht. Let that be clear. The Bundesverfassungsgericht is the best ally of our work. And I really mean this. It's not a captatio benevolentiae. I mean this deeply. Again, as a comparative constitutional law academic. They were the first court. In the meantime, a few of the newer member states, no longer new, but Slovakia and a few others have followed suit in the same line. But it's the first constitutional court which has characterized the Court of Justice of the European Union as the gesetzliche Richter des Unionsrechts, the lawful judge of union law, meaning that when a Supreme Court in Germany is not complying with its obligation to refer preliminary questions on interpretation of union law to the Court of Justice, and comes to an outcome without having referred, which is debatable in terms of union law, leaves scope for reasonable doubt, then the Verfassungsbeschwerde against that judgment of the Supreme Court in Germany will succeed, because the Constitutional Court says you not only breached Article 267, third paragraph of the treaty, but also Article 101 of the Grundgesetz, because the Court of Justice of the European Union is the gesetzliche Richter des Unionsrechts in conformity with Article 101 of the German Constitution. So it gives an enforcement mechanism for the obligation to refer incumbent on Supreme Courts in Germany, which is fantastic in terms of reinforcing the link between the two legal orders. So that's very important. Second, the Bundesverfassungsgericht has a 70-year-old, 75 years old now, jurisprudence in fundamental rights. For instance, when we are very exigent in protecting privacy and personal data, it is the case law of the Bundesverfassungsgericht which is the most consistent precedent in our research department which we find. So they are all things which people do not see. And then, of course, you have the very important, and in my view, academically too little commented, decisions of the Bundesverfassungsgericht, Recht auf Vergessen 1, Recht auf Vergessen 2, so two Beschlüsse, two orders of November 2019, under the presidency of the present president of the Bundesverfassungsgericht, in which they have taken over the Meloni-Aukerberg-Franzen case law, I say it in German or in Dutch now, case law, as to the applicability of the Charter of Fundamental Rights in the member state legal orders. Mm-hmm. So, where they make the distinction, if the union law legislation has completely harmonized a field of law, not leaving any margin for political discretion to the member states, then the compliance of the German implementing measures of such legislation must be measured, even in a Verfassungsbeschwerde before the Constitutional Court of Germany, on the basis of the Charter of Fundamental Rights of the European Union, and alone the Charter, and not on the basis of the Grundgesetz. It figures in so many words. And they rightly say that is Anwendungsvorrang. It's a primacy of application of union law. If on the contrary there is, so that is the Meloni case. That's Recht auf Vergessen 2. If there is a margin for political assessment, then they apply their own constitution, but which must be minimally as protective as the Charter and not endanger the unity and the primacy of union law. That's Aukerberg-Franzen. Mm-hmm. So, I mean, people do not see that always, and it's more complex. Mm-hmm. But on the whole, the authority of the Court of Justice of the European Union is very strong. We get almost 600 preliminary references per year, and most of them aim to inform the referring court on the scope of union law, with a view, potentially, to leave aside the application of conflicting national laws, and that in all the fields of union law, and that year after year after year. So the system works, and of course it's always like this, that people then concentrate on a few cases, but even those cases help the court to deepen the quality of its own work in the Hamiltonian sense. No power, but lots of authority when the job is properly done.
Another source of contestation or challenging is by national politicians. You can hear gouvernement des juges, and this was also towards the Court of Justice a core argument of the Brexiteers in the 2016 referendum. What is your response to that?
Well, there are many aspects to that question. The gouvernement des juges, or judicial activism more generally, it is often used as a label for judgments with which one disagrees. And it is not uncommon to have the same judgment being praised to the sky, and by another group saying it's judicial activism, it goes beyond. Take our Koen judgment on the need for Romania to recognize a same-sex marriage lawfully concluded or celebrated in Belgium for a Romanian US-American male couple. That judgment was praised as being correct in the whole of Western Europe, and it was even on a tone, it's rather cautious, because we had said, well, it needs to be recognized, but for the sole purpose of making free movement work. And in the Western European countries, France, Germany, the Benelux, the Scandinavian countries, they said, well, why be so cautious? Should that not be simply recognized across the board? After all, Belgium was competent to celebrate his marriage, and when you then make use of your free movement, that should in all member states be the same legal status. You're simply married. We have been cautious, because the union is a union of limited competences. Family law, l'état des personnes, the civil status of people, it's all national competence. So we said, no, it's only to make the free movement rules work, and in this case it's only a residence permit for the US national husband, which is an issue, so we confined our judgment to that. So the judgment was praised nevertheless as being a major breakthrough for the recognition principle, mutual trust, mutual recognition in the open area without internal frontiers. So it was rather cautious. A bit of criticism of judicial minimalism. That's also a criticism, that we should have gone a bit further, but let me that way. In the countries which do not know same-sex marriage, some even prohibiting it, they said that is judicial activism. So the same judgment. Now, what is the core of that judgment? Well, I'll tell you. It is the definition of the term spouse. Directive 2004/38, free movement of EU citizens, says that there is free movement for the union citizen and for the family members, defined as the spouse and then all sorts of children, direct, and also children of the partner, and it's all registered partnership, and they say according to which law that partnership should be registered, but the term spouse stays there naked. Not defined in the directive, no reference in private international law terms, which would be the member state whose law is called upon to define the term, nothing. Needless to say, we looked in the travaux préparatoires, and what did we discover? Long debates on the question to know whether that covered any type of marriage, in clear text, including same-sex marriage, or not. And they could not agree at all on defining it, and even not on a sort of collisionsrechtliche norm that is indicating a conflict of law rule, which member state would then be competent to define it. So in the end they say, this is as good as it gets, we'll leave it at that, a spouse, and if ever that causes problems, it will be for the Court of Justice to define. But what does this story indicate? It indicates that the legislative process of the Union, proposal from the Commission, parliamentary majority in the European Parliament, directly elected Parliament, the Council of the European Union, qualified majority, 55% of the state representing at least 65% of the population, with an indirect legitimation over the national political processes, they did not come to a better outcome than an undefined term, ein unbestimmter Rechtsbegriff. And they knew it. And they said, now it's for the court. So we reasoned the judgment. It's worth reading. Grand Chamber judgment. Trying to respect the limits of union competence, which is absent for the civil status of persons and for family law, with the upholding of the free movement rights, combined with, because there you are in the implementation of union law within the meaning of Article 51.1 of the Charter. So family law kicks in, Article 7, the right to family life. So we come to a reasoning, which is cogent, I think, but cautious, which is too little for the one side and way too much for the other side. That is what we are speaking of. So I think it's a matter of the judges and our court, we don't ask better than that the political process goes till the punchline, takes the decisions. But we live in a French law system of déni de justice. We must decide. We can't say that something is a political question, that we don't have the tools. No, there is a litigation. No one contests that it is within the limits of our jurisdiction. It's compulsory. We must decide. And so we do. So that is why this whole debate, given the nature of the European Union, is a sensitive debate. Now, a last element, you referred to Brexit. That is, again, from my academic perspective of comparative constitutional law, this is a very difficult topic. Why? In the United Kingdom, there is no constitutional court, nor any other court, having the similar function, the similar task, as a constitutional court. Different, for instance, from Ireland. Ireland is also a common law country, or the United States for that matter, common law country. But they have a written constitution, I speak of Ireland and of the United States now for a second, written constitution, and a Supreme Court which sits as a constitutional bench if need be. In the Irish Constitution and the Supreme Court Act, celebrated recently its 100th anniversary, it is provided. It's then a bigger bench. They call it even constitutional bench of the Supreme Court. And they can review the legality of laws of the Dáil, the Irish Parliament. The same as everyone knows in the United States, since Marbury versus Madison, 1803, Chief Justice Marshall writing for unanimous Supreme Court, which was 5 judges at the time, the Supreme Court can control the compatibility of an act of Congress, the full legitimacy of the House and the Senate, to the Constitution. And if it's not consistent, the court will quash it. And there have been several examples, as you know, over the past 220 years since Marbury versus Madison. In the European Union, we have the US-Irish system, and even expressly so, because it's in the treaty text itself. It's Article 263, the action for annulment, it's Article 267, TFEU, it's the validity control for preliminary references. So we have judicial review of legislation that is on its compatibility with the constitutional block on which the Union is founded, that is all the treaties, and the Charter of Fundamental Rights. In the UK, that is totally absent. An Act of Parliament of Westminster can never be quashed by any court in the United Kingdom. And so for them, the idea was each time, it was of course not their problem that we would quash an EU legislation, but when we interpreted in a random preliminary reference EU law to the effect that an Act of Parliament of Westminster was seen to be in conflict with Union law, and that of course, under the principle of primacy, a UK judge would have to leave its application aside when it's Poplavsky 2 now, our Grand Chamber judgment of 2019, when rule of national law conflicts with the rule of union law having direct effect, it triggers the obligation to leave aside the rule of national law. So, of course, there were, over the years, many examples where we had interpreted union law, and as a consequence of that, UK laws, Acts of Parliament of Westminster, could no longer be applied by UK judges. So what they said was, this court in Luxembourg can do things which are totally unthinkable for any English judge. And these English judges are our own judges, entirely so. Whereas this court in Luxembourg, yes, there is of course one British judge as a member state, because every member state has a judge. But let's not exaggerate, for them it's mainly foreign judges. They see that from London. Eh? So I think there was really a national constitutional law understanding of the separation of powers, which they strongly have in the UK domestic constitutional order, which, as you know, is no written constitution as such, but there are constitutional principles inherent in the common law, and there is an understanding of the separation of powers, which started with the king can do no wrong in the Middle Ages, and gradually that, after the Magna Carta 1215, it became gradually the parliament can do no wrong, but it meant that no judge can ever contradict the parliament. And so that was for them a sort of a conceptual problem that these judges in Luxembourg, or for that matter in Strasbourg, by the way, for the Human Rights Court, they can contradict a law of Westminster and make that it in the end is not being applied. That's why in legal terms they said take back control. Mm-hmm. So I don't think it is to be confused with this activism debate. And you see it in Germany. In Germany, they have a strong tradition now of constitutional review of legislation. So when an interpretation of union law we give leads to a problem of incompatibility of German legislation with the union law, German politicians may say, well, we don't like it, but in fact, yes, we know the phenomenon. It's the same when the Bundesverfassungsgericht quashes a law of the parliament. And of course, we never quash a national law, but we will at most give an interpretation of union law, which then triggers the obligation to leave aside the application of national law. And then it's again the national parliament which has to reform its legislation so as to make it conform to union law. But on the continent, we have sort of a shared understanding that that is the task of judges. That is not the case in the UK, and it is one of the big splits even today between the United Kingdom and the United States in terms of constitutional review of legislation.
In this context, this is a small digression, that because we are talking so much, or you are talking so much about the United States. So a small digression, and also still talking about how national politics and governments can challenge or influence the judiciary. We see that the Supreme Court of the United States, in its composition, is very polarized, if I may say, and potentially misused to impose a certain political agenda. Do you see any similar potential risk for the Court of Justice?
Here, my answer is clearly no. And there is a very simple reason for that. In Europe, we are proceeding a bit on the Napoleonic model of judgments which are deliberated and come to a single collegiate outcome. It's the model also of the Belgian Constitutional Court, for obvious reasons. With a country with two main communities, Flemish and Francophone, all the judgments of the Constitutional Court are deliberated and decided in Belgium by benches composed of Flemish judges and Francophone judges, and with the obligation to come to a single judgment. We have the same rule here. And that is a supreme guarantee for not having this polarization within the court and vis-à-vis the public also. So in the US, it's the common law system of the US and also of the UK in that respect, where every judge makes its own opinion, but in writing, or at least is entitled to make it. Sometimes he or she will join the opinion of a colleague, but it's still the names, and normally they can make small additions, and that leads to these dissenting and concurring opinions, and sometimes you have to really count very well to know which reasoning now gets the majority, because you might have 5 against 4 as to the outcome of the case, but even these 5 might sort of use different routes to finally come to a similar outcome, to come to this 5 against 4. That is unexistent here. So the primary law of the Union is not a court of justice which decides that. I always have to explain that to academics who find it a brilliant idea to have dissenting opinions, etc., because of course it feeds in their academic writing, and I can understand all of that. But now you see, with what's now happening, and I will not as a president of this court comment this further, but I'm sure you follow also the news from the United States on a day-to-day basis as a lawyer. You see immediately what the limit is of this possibility of individual opinions and 5-4 decisions in major issues which are nationally divisive. We can't have this because the member states were smart. They said that the court must always sit in an uneven bench. The composition of the court is independent from the nationality of judges. And by the way, I must say this court is not an international court, like the International Court of Justice of The Hague, or even the European Court of Human Rights, which is an international court, where applicants are suing a state whose judge must be on the bench. Nothing of that here, for obvious reasons. We are not judging national law. We are not judging member states. We are only interpreting, applying, and enforcing union law. This court is not even a supranational court, because it puts the court outside the national systems. No, this is a court which makes part of the judicial systems of each one of the member states. This court is an Estonian court, is a French court, is a German court, is an Italian court. It's a court common to all the member states. It's a common court. It's not something outside, whether it's supranational or international, no. It's a common court. And as a common court, we interpret, apply, and enforce the law common to 27 states. Why is that law common? Because these member states have decided to exercise part of their own sovereignty, I repeat it, in common. Why? To be more efficient and to be more effective as to the outcome of the policy. And this can be the fight against climate change, or it can be asylum management, or it can be internal market aspects, or the common currency, or what have you. So that is the paradigm. For that, since it comes to interpreting the rules common to 27 states, the judgment must be a glossary, because most of our judgments are interpretations, on that common rule, which is henceforth to be understood in the way the common judgment has found the law. And the consequence of that is, and I think I may say that without betraying my oath of office, in which the judges and advocates general promise to respect the secrecy of deliberations, but I can tell you that the spirit in which the deliberations take place is always very constructive, because everyone knows that starting from one's initial view, we have to exchange and to listen deeply to one another and to combine the strengths of the different arguments developed around the deliberation table to come to, it's also the role of the president, to a synthesis which can be a strong basis for judgment, which is a common judgment, which takes all the steps to get to that common judgment, and which commands the authority based on the force of the reasoning developed with all those around the table. So it's not we have many contacts, as you know, also me academically, but also as an institution with the US Supreme Court. And they were here with a delegation last September only, with the Chief Justice and a few other justices. And they were in full admiration for the fact that we succeeded in coming to judgments which they found very convincing, very strong, and they adhere to also. They said the fact that you can do that with 15 judges around the table, which is our normal composition of the Grand Chamber judgments, and to construe the law to make it work as a source of law common to 27 states, and to do that with judges around the table irrespective of their nationality, but as, I would say, artisans of union law, they found this fantastic. And I think that is the spirit of this house. And we're also different from the US Supreme Court, to which you referred, but it might also be for Supreme Courts of other states. We are far less individual egos. The judgment is a judgment, and it's the judgment of the court. Yes, the names figure who was sitting in the case, but it's never associated with a particular judge. Even the judge rapporteur, everyone knows that it is one of the judges who takes the lead in implementing what a college decides. But it's one voice on equal footing with all the others around the table. So this sort of exercise in modesty also, that you don't try to shine on television, in television studios and vis-à-vis the media with your opinions, etc., which, as you know, is largely done in the United States, that is all absent here. And it needs to be absent in accordance to our code of ethics. We must always be very restrained. It is the college which decides, it's the court which decides, and everyone works on it in a collegiate spirit. And that's the strength of this court, also in these moving times we now live in terms of the rule of law.
Thank you. If you agree, I would like to move on to a totally different topic. I mean, a bunch of topics with about the functioning, about the work of the court, and I will have two questions in that respect. The one is about the whole process of digitalization, and how, in particular, and I would be interested in how, in particular, artificial intelligence is impacting or will impact the work, not the case law, but the work of the Court of Justice in the coming years.
Well, yeah, you're absolutely right, Jean-Philippe. It is a very important development, and we are already AI supported in the translation field. Mm-hmm. We have, as you know, a very effective Directorate General multilingualism, which is to be divided in the huge group, that's the biggest group, more than 80% of that Directorate General, and then we speak of several hundreds of people, the so-called lawyer linguists. Mm-hmm. And of course, their work is now already, in an important way, supported by what we call beautifully in French, la traduction neuronale, mm-hmm. But that's AI-supported translation. Do not ask me for further details because I'm not a specialist in it, but it works this way, and it is being refined in our own AI lab to further define what we need in terms of feeding in the algorithms which we can buy on the market, but to feed them with our own documents and work so that it operates as a closed system for our own needs of legal translation. That's, of course, revolutionary. Mm-hmm. In which also the colleagues who work in that in those directorates, because there are several, under that Director General of Multilingualism, will also be able to engage more in comparative legal research, in fine-tuning of text, because the human touch, of course, is always extremely important to feed the machine, but also to work on what the machine has produced, and which, after all, may, in some cases, give the opposite meaning of what was really meant in the original language, so you have to check it very, very carefully. So those people will, in fact, increase the quality and also be able to do parallel tasks, which they previously had too little time in a way. And then we also have AI tools already to support the administration. Do not forget that the Court of Justice is a fully self-managed institution. We don't have an EU Ministry of Justice or an EU High Council for the Judiciary. Some national colleagues tell me, be happy about that. Yes, I am happy, but nevertheless, it also means that we have to do everything ourselves. So it's a fully managed house, and it ranges from the budget, and then also to give the, in view of the décharge, to account for what you have been doing the previous year, which is totally normal in a democratic system, such as the EU. Then you have all the personnel, all the different services which support the judicial work of the two courts, the Court of Justice and the General Court. So it is, it's a huge institution, and there the AI tools are of course here in support of the administrative aspects of the self-management structures. And then of course it can also be used for research purposes. So for instance, but again, it's a closed system of feeding the machine that you say those 100 hits which you give, which you get on a particular legal topic which you want to research, for instance in the framework of an opinion of an advocate general, summarize them to me so that I can now select which ones are really decisive in the case. So that's also something. So it's not taking the place of the human decision maker, but we have now one of the challenges, and you know that as an academic just as much as I do, we now have a clear oversupply of information on all levels, in scholarly writings, in policy documents, in everything. And so AI can of course be supportive in order to make a meaningful, a sensible selection of what is really worth pursuing in depth and what is not. So that's also an element which I hear colleagues sometimes refer to. In any event, we have here an AI management board that's fully further developed. There is even communication about that on our website. But I can tell it's of course totally absent in the judicial decision-making proper. That's absolutely absent. It's at least the stage in which we are. It's that's solely human work. And that also includes the advocates general for the drafting, etc. So it's so that's the present state of play. But our files are all digitalized. It's not AI, but so everything is available on the screen. It's which of course is an enormous advantage for the practical functioning of the court. And there are more and more colleagues who are with their computers in the hearings, in the deliberations, so it depends a bit. Some still work on paper, but even then, it's a mixture of paper and the computer. So that's very good.
Another question is, I would say that those who follow the work of the court have noticed that the court has become more transparent, more communicative. I mean, we see this with the live streaming of some grand chamber hearings. We see, we are very impressed by your communication on social media, for example. It's a bit a tricky story something tricky for a court. I mean, can you tell us a bit more about the strategy of the court and what the limits of such transparency policy can be?
Yeah, well, it's one of the things since I've become president now 9.5 years ago, which together with my colleagues, because everything here is collegiate and after a debate, in fact, almost consensual, we have said, well, the Court of Justice of the European Union is a court common to 27 member states. It must be seen to be such a common court. Now, with the geographical scope of the Union always extending through the successive waves of enlargement, you cannot expect everyone who is interested in the court or in its case law in a particular case to come to Luxembourg and to follow the case law. So we did a study and we saw that our visitors come for more than 80% out of the 3 Benelux countries and the adjacent regions of France and Germany, including the city where ERA is established. That is not equality of treatment of the citizens of the Union, stretching from the northeast in Estonia to the southwest in Portugal, or the northwest in Ireland till the southeast in Greece or Cyprus. That was the concern. It's as simple as that. And all my colleagues understood this. So other courts around the world are doing it, including the Human Rights Court in Strasbourg, but also national Supreme Courts. And at that point in time, the UK Supreme Court was still a member state Supreme Court. So they're streaming the hearings. So it was an adaptation, but I convinced the colleagues and they are now very happy with it, and it's been generalized now. We had, of course, to see for personal data protection and so on, but it was carefully done and that has not caused any problem. So we started in April 2022, so we are now up to 3 years of streaming of all the Grand Chamber hearings and the full court hearings. And it must be said also for the member states, especially the agents of the member states, this was a big adaptation because they are of course followed, etc. But now they're also very much used and they're sometimes also a bit proud of what they can do because they're of extremely high quality, all of them, and that is independent of whether you like what they say or not, but I mean, they really give the best of themselves to make a decent contribution. So it's important that the public sees that a court is something different than a legislature or an executive. It's also to make clear that what we do is saying the law, like Article 19 of the Treaty on the European Union says it. The mission of the court is to uphold the law in interpreting and applying the treaties. Of course, the law based on the treaties. So that is what we do. And that is a dialectic process with several parties defending different positions. And the court's judgment is an outcome of that process. Justice must be seen to be done. So a court for me should be a glass house. It's my firm line since almost 10 years, and actually also before when I was not yet president. The only thing which is secret is the deliberation, for the reason already stated, that you need there a free space, ein Freiraum, a free space in which you can exchange fully openly, also with the assurance that you can come to a better view in that exchange, which might be different from your initial view, and which very often is, otherwise we don't advance in a case. That is the reason why, when judges and advocates general take up their office here, they promise to do their best, to be independent, and then to respect the secrecy of deliberation, not only during their term of office, but any time thereafter. And so, when that is secured, those 3 components, all the rest is open, and especially the court proceedings. So, when we now had this recent reform, in which we transferred, as you know, in 6 specific areas, preliminary references to the General Court. That's not now what I want to talk about. But in that process, the European Parliament asked us to even increase the transparency. And you may be aware of the fact that the Parliament amended the legislative request of the Court, and the Court agreed with the Parliament, to provide for the publication on the internet of the briefs which the parties file in the preliminary reference procedures, so the observations. Of course, when the author of the observations objects that it be published, it will not be published. But a few objections, people again over time get used. Quite many have been published already, because it's in force since September 2024. And it stays on the internet, so that academics and also lawyers and pupils in school, whoever has an interest, can see, but what did this member state actually say about this case? And does the judgment really respond to that? So we make our life more difficult. Justice must be seen to be done. So it's not by ease of the judges that we make all of this public. No. We want our life to be more difficult, so that the outside world can see the judgment and can see what has been argued before us. It's all public. So that is very good. It again is an incentive to increase the quality of our judgments, because we know the judgment will be read with a full public knowledge of what has been presented before the court, except when the author of the brief objects. That's not our responsibility. So justice must be seen to be done. It's as simple as that. That is the reason.
Thank you. We're getting close to the end of this interview, and my last question has basically nothing to do with the Court of Justice. While preparing this interview, I came across the fund Lenaerts Press. It's not secret, but
no, it's absolutely public.
Press is your wife?
Yes, absolutely.
And can you tell us a bit more about...
It's almost 45 years.
Oh God.
You started very young.
Okay. Can you tell us more about this fund and its aim?
Yeah, the fund Lenaerts Press is a fund created inside the University of Leuven in Belgium. It's the Dutch-speaking University of Leuven, which is both our alma mater. We are both lawyers of that university. And I was then, during my whole life, as you know, a professor of European Union law, comparative constitutional law, and a few other things over the years. But this fund, we created it in 2017 in order to promote knowledge of the European Union for youngsters between 15 and 18 years of age. That is, in the compulsory years of secondary education. The idea being that when you are a national of a member state of the European Union, and hence a citizen of the Union, you simply need, in terms of constitutional literacy, not only to know the constitutional structures, political structures of your own country, which are normally in one or another class taught in these years of secondary school, that people have a basic understanding of how the state operates, without having any notion of the fact that your state belongs to a bigger ensemble, which the European Union is. That is a common governance structure, a common legal order, which operates in accordance with the ground rules of play laid down in the treaties on which the Union is founded, that you know something about the values of Article 2 of the Treaty on the European Union, which are crucial in the times we live: human dignity, freedoms, democracy, rule of law, human rights, in a society characterized by pluralism, tolerance, equality, including the protection of the rights of minorities, solidarity. Look at what's now happening in the United States. You will see that constitutional literacy at national level, with this EU dimension, is consolidating the understanding of young people of the system in which they live. So that is the task of that fund. And the fund finances projects which are done at universities. And my wife, who after having raised 6 daughters, our 6 children, she restudied and did a Master of European Union Law here at the University of Luxembourg, which led to a PhD thesis, which she defended when the first grandchild was already sitting on the first row in the public defense. And I say this because this thesis is published at Nomos Verlag in Germany in English language under her name, Chris Grimonpré. And yeah, the Dutch say ge, in French they say Grimonpré, but we say Grimonpré. And it is precisely on that topic. Citizenship of the Union cannot exist without the citizens knowing that they're citizens of the Union and that it triggers the political rights laid down in Title 2 of the Treaty on the European Union. The vote for the European Parliament, but also the vote for the national parliament. And you will agree with me that what happens in national elections is just as relevant at the EU level. Why would otherwise people be so interested outside a member state on who wins the election within the member states? Whether it's Poland, Hungary, Germany, or France, right? So that is almost the mathematical verification of what we're saying. So the thesis is on that, and now the fund Lenaerts Grimonpré operationalizes the ideas of that thesis, which is in open access on Nomos Verlag. Doesn't cost anything. You can read it there. And especially my wife, because I'm of course full-time here, she developed with the university team from Leuven, but from many other universities all around the European Union, a video clip and material which will be used in schools. All of that is accessible over the links which you find on the website of the fund. Mm-hmm. So I hope that in the times we live, where democracy, rule of law, human rights are often being questioned, and where autocratic mechanisms come again to the surface and people sort of distrust the political scene altogether because they don't understand the system in which they live. Such a project might help to reverse the current, because all our case law here on democracy, on the rule of law, and you know that we have more cases than we would probably even like to have, because a judge only delivers a judgment when there are problems in the field. The judgments are the expressions of pathological complications in the field, right? So you would prefer not to have to deliver them, but we have to. But a court cannot alone consolidate democracy, rule of law, and human rights. Civil society needs to do it. The media need to do it. The social media need to do it. But it all presupposes education. People must understand the system in which they live. And this, in the last years of compulsory education, after which some will become plumbers and builders and agricultural workers, industrial workers, some will further study in engineering or in medicine or whatever, but they will understand the system in which they live. That's the purpose of the fund.
Thank you very much. Thank you very much for this conversation and for your time. It's been a pleasure and an honor.
My pleasure. Thank you.